Hi, this is Tanner Rainbolt. This is EDL 850 Module 12, tort liability. So first thing, what is a tort? It's a civil wrong or wrongful act. It could be intentional or it could be an accidental from which injury occurs. And the school district or the school personnel can be liable and charges can be administered from this. The first of my five, public school lawsuits. The first one was Mosley versus Portland Public Schools in 1987. The victim was stabbed with a box cutter in the hallway, and no staff member was supervising. So it was during her lunch period, and it started out as just a normal fight, and then a girl pulled out a box cutter and cut the defendant. And the Oregon Supreme Court ruled in favor of the defendant and said that the school was negligent and that they should have had an adult supervising the hallway. So when it comes to my school, if this were to happen, what the reactive measures would be was obviously the person that was stabbing them would definitely be suspended or expelled. There definitely would be some upset parents, and if that was the case, I would assume a possible lawsuit would occur as well. When it comes to being proactive, making sure that there's proper supervision in all the hallways between passing periods, before, after school, during lunch, there should have been a staff member out in that hallway. And, when it comes to, the principal, you got to make sure that the staff is where they need to be. And when it comes to the ethics part, teachers need to be in their supervision spot. Like, if you send out, for example, before, after school, during lunch of who's supposed to be where, the teacher should be held accountable. They need to be in that spot at that time. That'll help prevent things like this from happening. The second lawsuit was the Skinner versus Horry County Schools in 2008. This case is still ongoing, but the school was sued for false imprisonment. It was a second grade student who was forced to do her work on the floor. She was not allowed to sit in a chair and do any of her schoolwork. This happened for a month. The mom sued the school district saying that, that it was false imprisonment and things in that nature. So it's still ongoing. Don't know, what's going to go on with that. But if this happened in my school, there'd definitely be some upset parents. I feel like the principal should be talking to the teacher of what an appropriate consequence is. Maybe not sitting in their chair or having to stand for a little bit or something like that. But having the student sit for 30 days is very excessive. Being proactive, just talking with your staff about what is and isn't appropriate punishment. If it keeps going on for that long, I feel like administrators should get involved. I don't think a student should be sitting every day for a month, on the floor. And then when it comes to ethics, just at the classroom management, being able to discipline students and, being effective within that. I don't think that was effective for either the student or the teacher when it comes to this case. The next case was, I try to say this right, Hoosac versus Chilliwack School District, 2009. They ruled in favor of the defendant. This was negligence by the PE teacher. I chose this case because I am a PE teacher, and so I thought it was interesting. The student had been gone for, I think, a couple weeks. He had problems with, being present in school. So he came back in at the end of their field hockey unit in PE, and he got injured. So the courts found that the PE teacher was negligent and that he shouldn't have let him back into the competition because, one, he hadn't been there in 2 weeks and his skills in field hockey were not very well, and so it caused the injury. If this were to happen in my school, I feel like, that my administrator would just ask, was there evidence of safety measures? Did you foresee this happening? Things in that nature. Being proactive wise, I would say, allow students to work their way back into it. Just don't throw them into it, especially if he hadn't had any time, with the unit. Obviously, his skills, his endurance and stuff wasn't going to be as high. So you are looking at, a greater chance of injury. And then when it comes to just the ethic based, just making sure that for especially as a PE teacher that you have quality lesson plans, and in those lesson plans there are safety measures that you're going over with your students. I think that hopefully that could prevent some of the things from happening. The next court case was Munn versus Hotchkiss School District. It was in 2015. This is a field trip. I guess it was beyond a field trip. It was a summer trip where the girl and the school was in China, and she got bit by a tick. And the tick had a disease which the girl ended up suffering neurological damage and could no longer speak. The parents schooled the school district for foreseeability. Basically, the school district lost the lawsuit. They said that the school should have been aware that this tick was had an outbreak in China, and the parents were upset. Obviously, they did sign a parent waiver form, which I read in a couple of the articles from our reading that parent waiver forms aren't always going to hold up in court, even if you do sign something saying you're aware. The school district can still sue possibly. I would say being proactive, getting parent waivers, also informing stakeholders of possible injury of harm that can occur. Ethics-wise, whoever planning the ship, they should have been knowledgeable in where they are going and what problems can occur, especially if, for example, the tick, if there's an outbreak in Lyme's disease, just making sure people are aware of that. The next one was Mitchell versus Cedar Rapids Community School District in 2013. It was a special needs student who was sexually assaulted off school grounds. So basically what happened is that this student had two SPED teachers who were aware of an inappropriate relationship between two SPED students, and they kind of just let it happen, and they didn't really step in or say anything to both the students or say anything to administrators. And so what happened is these two students ended up skipping school one day, and they went over to the defendant's grandparents' house, and the defendant was sexually assaulted by the other person. The school was sued for negligence, just not reporting the inappropriate relationship to parents, to the administrators, even talking with the students about it. For my school, some reactive measures would definitely be upset parents, upset administration that they weren't notified about this from the teachers. Being proactive, talking with teachers about reporting things to admin if there's any appropriate things going on in school, and the administrators need to know so they can let parents know and talk to the kids about it. And then ethics-wise, just the teachers need to make sure that, especially I'm at a middle school and some of the relationships can get inappropriate, and you got to make sure that teachers are reporting those, talking with the students, talking with administrators, talking with parents, at the all the stakeholders, so we're all on board. So anyways, that was my module 12.